Yes, Mr.
My Lord, putting the question of seriousness in terms of providing guidance to judges has proved very helpful to clarify my position on stage 2 of the proposed test for when relief of this kind ought to be granted. And I also hope that what I'm about to submit is a better answer than that which I gave to my Lord Justice Warby on his previous question on the various thresholds. And to put it succinctly, my submission is that activity sought to be restricted must be such as to amount to the conduct element, and I insist on the conduct element, of a recognized unlawful activity. And so that unlawful activity can of course be of various kinds, with or prompted by this court's intervention on the previous occasion. We have of course identified the conduct element that we now consider the correspondence that we rely upon to amount to, and we say that it is the conduct element of the offence of malicious communications. These are messages which are indecent and grossly offensive.
So where is the offence of malicious?
It is at tab 4 of the authorities bundle, page 7 to page 10.
This is the Communications Act, is it?
Yes. Yeah. Malicious Communications Act, 1988.
Sorry, page 4?
Page 7 of the bundle, page
7.
10 of the PDF, probably.
Malicious Communications Act.
Yes.
Okay,
So
I haven't seen that mentioned before.
Is that where you got the revised language from in your cut down version of the order?
My lady, indeed.
Okay.
And the reason I obviously insist on emphasizing the conduct element of activity that would be otherwise unlawful is that if you go on to consider what constitutes the offence of malicious communications, you need to prove that a purpose, or one of the purpose, was to cause distress, anxiety to the recipient, to any person intends, etc. And so we say that the trigger for the exercise of the court's inherent jurisdiction in these types of cases is a conduct element of activity which would otherwise be unlawful. And the upshot of that, which we'll come on to when we get to stage 4, namely the balancing exercise, is of course it means that judges, when faced with this kind of application, will then have the benefit of guidance in cases which have considered proportionality under, for instance, the Malicious Communications Act, or how freedom of speech is treated in the context of harassment. So if I stay then, having said that, at stage 2 of the test, and bearing in mind the submissions I made earlier about the importance of solicitors as officers of the court to the court's ability to discharge its function in accordance with the overriding objective, I note that the advocate at paragraph 22 of his skeleton, that's supplemental bundle tab 7 at page 207, page 210 of the PDF. We will hear the advocate in due course, but he there says that he agrees that abuse of a party's legal representatives, and I quote, might reasonably be considered inimical to the proper administration of justice. And there are, in my submission, two ways in which the court, or a court, can assess this. And the first is that conduct that is prima facie unlawful on its face, and as Mrs. Justice Hill found, not only impinged on the solicitor's ability to fulfill their duties to the court, but also had a detrimental effect to the conduct of the proceedings, is inherently sufficiently serious in principle to warrant the court's intervention.
I mean, how can that be? I mean, a document, let's take your document example. The document, the skeleton argument, gets left out of a bundle, which is a nuisance and causes extra work for lots of people, but is later recovered. Automatically means there has been conduct which is inimical to the proper administration of justice and merits an injunction.
This is at a stage where the court would already have found that there would be material interference with, there has been or there would be, if the conduct has persisted in material interference with the process of the court. It would also, this is at the stage where they find whether it's sufficiently serious to warrant it. So it's, of course, if that is the only thing that is relied upon, a court may take the view that, frankly, the interference is not sufficiently material that we need to consider ourselves. It is.
But I mean, the advocate appears, I'm sure he'll speak for himself in a minute, but he appears to be saying that any abuse of solicitors is inimical to the proper administration of justice. Therefore, your stage one is satisfied. You may, I suppose, not be sufficiently serious, but if it's inimical, if abuse is inimical, then I suppose it is sufficiently serious.
Well, Lord, at stage one, the question is, well, has there been or will there be interference with the process of the court? I mean, this is a sort of an objective test, a question of evidence that the court will need to ask itself. At the seriousness level, the court will have to find, well, has the conduct which has given rise to those, or which would give rise to the material interference that has been found, is it such as to be prima facie unlawful?
Okay.
And so at that stage, the court may, in my submission, take the view that conduct of that nature, which has had a material impact on proceedings, ought to be restrained. The other perspective, which is not necessarily an alternative, but it's certainly an additional perspective, is that the court may consider it appropriate to take preventative steps to ensure that its officers are not subjected to this kind of conduct when they act as such. And I would simply refer in this regard to what is stated at paragraph 30 of the witness statement that Mr. Gailani made in support of the original application. That's at tab 11 of the supplemental bundle at page 272 of the PDF 269 of the bundle. And it's simply for the point, the reference there is to recent international attention that has been given to the need to protect lawyers in the course of their work, effectively, in the exercise of their duties in the public interest. So I would submit that taking preventative steps to prevent solicitors from being subjected to conduct which is prima facie unlawful and has an impact on the conduct of proceedings is both welcome and consistent with principle. So stage 3 then, obviously there needs to be, as I said, there needs to be coherence between the jurisdiction sought to be exercised, and the reasons for it, and the relief that is sought. And we have, as the court will already have noted, taken on board the criticism that was made on the last occasion of the formulation of the relief sought before Mrs. Justice Hill.
Where's your new relief sort.
It is core bundle, tab 1, page 8. I'm grateful to Mr. Field. It might be PDF page, I think PDF page 9 actually.
Well, this is the amended version. Is it possible to see a clean version?
We can create one, yes. And
I find it very difficult to read on this. It's very small print.
can I perhaps read it into the record?
Well, you can read it into the record, but that won't help. Just get me a clean copy
Yeah.
by email or...
We will organise that.
Yeah, thanks.
Paragraph 1 now reads, the defendant is prohibited from addressing to the claimant's legal representatives or any person acting for or on behalf or at the instruction of the claimant's legal representatives any message or communication which is indecent or grossly offensive to or about any such representative or person. And so we have...
What is being indecent? What is a message which is indecent to a person? I mean, not very good English. I mean, grossly offensive is a subjective test for the recipient.
It's,
I mean, one thing will be grossly offensive to some and others will laugh.
well, now we are relying, and we are, for good cause, we are relying on the definitions and the tests that would be applied under the Malicious Communications Act.
So this is just taken from the Malicious
Yes.
Communications Act. I mean, what is the juridical reason for doing that? I mean, the Malicious Communications Act is jolly new. The inherent jurisdiction of the court is jolly old.
Well, malicious communications, well, it's from 1988.
Sorry, new to me, Mr.
The point, it relates to two of the stages of the 4 stages of the test which I put. The first, as I just went through, it assists now and I think makes it clearer what the threshold test for seriousness is when a court considers an application of this kind. The other point was obviously a criticism that I think was made on the last occasion, that the relief sought needs to be clear to the person who is made the subject of it. Now, I maintain that in the circumstances that this application was made, it was perfectly clear to Ms. Okunola what kind of conduct, or indeed what kind of communications it was that was sought to be restricted. But we accept that the formulation was not adequately principled or tied to concepts which at least an individual with legal advice, which I think is the best we can do, could elucidate, would be covered.
It wasn't adequately clear to a person without legal advice.
Yes, and I think indecent and grossly offensive obviously comes closer to bearing what a lay person would understand. And I think that is the best we can do. It is at least a recognized legal concept which has been elaborated upon and which a judge with assistance from the bar could obviously apply. And the second point, so the assistant, or the reason why it has been reformulated as such is obviously that the relief sought needs to cohere with stage 3. It needs to cohere with what it is that we are seeking to achieve. But I do wish to make one important distinction. There was no change in terms of, we still rely on the same underlying evidence. We still rely on the same communications to establish the need for the relief. And albeit it was formulated with insufficient precision before Mrs. Justice Hill, a judge, when considering what relief to grant, is not bound by language that is proposed in a draft order by the applicants. And so the fact that the relief, the formulation of the relief, was not perhaps as clear as it could have been, did not, as it were, preclude Mrs. Justice Hill from granting it in a form which would have been more appropriate. And in any event, the court will have noted that is not the basis upon which the application was refused. That brings me to stage 4. So now that we have effectively established that which we have on one side of the scale, we can then weigh that against, in the proportionality exercise, anything that ought to be put on the other side, any countervailing rights and interests. And starting then with what's been referred to as a litigant's immunity, I note that the advocate and I are, I think, ad idem on this point, and I do rely and refer to the advocate skeleton, particular paragraphs 55 to 56, which are in the supplemental bundle, tab 7, page 219 of the bundle, so page 222 of the PDF. And our submissions on this point are in our skeleton at paragraphs 25 to 26, in the same supplemental bundle, tab 5 this time, bundle page 183, PDF page 186. And my starting point is the case of Munster and Lamb, which you will find at tab 11 of the authorities bundle. If we can look at page 82, this was a case where a defamation suit had been brought against an advocate for submissions made in court. And what, in refusing, effectively, in applying the immunity, in refusing the suit, what Lord Justice Fry says at the top of page 608 of the report says is that a court of justice has control over all proceedings before it. It has very great powers, to which I need not particularly refer, with regard to witnesses, solicitors, and counsel. The court can always check improper conduct. And I need to guard myself slightly against a risk of circularity. But what Lord Justice Fry, in my submission, is saying here is that if conduct is improper, such that it impedes the court's process, addressing that conduct is not prohibited or prevented by the existence of the litigant's immunity.
Well, the problem comes back to one that my lord has raised several times, which is this actually a completely new claim for an injunction where proceedings have to be issued in order to obtain the injunction, or is it control of the existing conduct of the existing proceedings? Because if it's the latter, then it is closer perhaps to a situation where you are bringing proceedings based on something that has occurred in correspondence in the former proceedings, which begins to look like these cases.
Well, Lord, I'm grateful because it allows me particularly to highlight what I think is the nuance that arises from the dictum by Lord Justice Fry. And it is that, in fact, this was not a new claim. I've taken you previously to the application notice. This was a Part 23 application in the context of extant proceedings. there was no jeopardy against the defendant, Miss Okunola, on that application. No remedy was sought against her with respect to prior conduct. Now, the distinction that we get from Munster and Lamb, I think, is precisely that we would have a different discussion were it the case that the solicitors, or those instructing me, had brought, for instance, harassment proceedings against Ms. Okunola on the basis of these statements. But the proposition upon which I rely on the application that was made is that the immunity, litigant's immunity, does not deprive the court of its jurisdiction to control its own process. And so as long as that is what the court is doing, a litigant needs simply to comply.
I don't really understand how Munster and Lamb helps you, because this is an action, standalone action brought for words spoken
Yes.
in court. So the immunity is an answer. No one needs to bring in a separate proceeding to raise it. They just need to say, this is my defence.
Well, so in Munster and Lamb, defamation proceedings were brought with, there was a substantive relief, a separate claim with respect to something that had been said in court. That is not what we are doing here. And what Lord Justice Fry is saying is that, well, I am not being asked to police my procedure here. I'm being asked to grant you, effectively, judgment, damages, with respect to something that was said in court in prior proceedings. That I will not do, but it does not mean that I could not have, or indeed would not have, exercised my inherent jurisdiction to control my own proceedings, as and when this conduct had taken place. And I think this is also picked up by Lord Justice Ricks in the Iqbal litigation. If we look at paragraph 54 of Iqbal number 1, which is tab 33 of the authorities bundle, page 655 of the PDF, 652 of the bundle,
This is the first appeal from Judge Ellis.
yes. What Lord Justice Ricks there says is that whatever the hardships involved in litigation,
What
So-
paragraph are we?
54, it's sort of halfway level with number 59.
54. Yeah.
It says, whatever the hardships involved in litigation, it is not the occasion for irrelevant and abusive dirt to be thrown as part of a malicious campaign. And he continues a little further, even litigation whose natural contentiousness also requires its own freedom of speech can exceptionally be abused. He says, I would, however, equally deplore satellite litigation. And so again, to emphasize, the question of immunity would be posed in different terms on an application for Ms. Okunola to be held in contempt, for instance, or indeed on a damages claim for harassment on the basis of the communications in evidence. But we say the court's power to control its own process, which is what we are dealing with here, is not intended to be limited by the immunity in this sense.
Do you rely on that paragraph as authority for the proposition you just put to us?
Yes. I mean, I rely first and foremost on Munster and Lamb, which has been relied on in the Iqbal litigation as well. And so good authority, the distinction there holds true.
I'm getting a bit lost as to what the proposition is. Is the proposition that the immunity, whatever it is, has no bearing on the exercise of the inherent jurisdiction to control the court's procedure?
Yes.
And do you cite paragraph 54 as authority for that?
In the sense that the immunity is not there to protect against what is referred to as irrelevant and abusive dirt to be thrown as part of a malicious campaign.
But the question of immunity wasn't at issue on this appeal, was it?
Well, I'll go back and read properly, but the context of it is the defence to the claim that was raised. And it's a harassment suit. Yes, it says, page 643, the claimant brought county court proceedings against the defendant under Section 3 of the Protection from Harassment Act, alleging that letters that have been sent as part of litigation amounted to harassment.
Yes, he did.
Yes.
And the court struck that out, and the Court of Appeal said that that was wrong because they could amount to harassment.
Yeah.
Then the defendant put in the defence of immunity. It came before me, and I struck it out because it was immune.
Yes.
So I may have been right or wrong to do that, but
Right.
it was only at that stage that the immunity issue arose. I don't see how the fact that an issue that wasn't raised before the Court of Appeal in this case can be said to be determined by an overture dictum, paragraph 54 of Justice Ricks's decision, but maybe I'm misunderstanding.
The way I've understood this is Lord Justice Ricks, obviously, he sent it back down because he took a view on the perimeter of, as it were, the immunity and what could and could not be covered by it.
No, but I think that's certainly not the analysis that I engaged in when I did have the question of immunity raised before me on appeal from Judge Faber in the county court. So what happened here? The primary question, which was dealt with in this judgment, is whether this is conduct that could amount to harassment within the meaning of the statute.
Yes.
County court says no, Court of Appeal says yes. No question of dealing with the defence of immunity. That was then raised in a separate defamation case where Judge Parks said that it was immune. Appeal to the Court of Appeal was dismissed. The same defence was raised in answer to the harassment claim. Judge Faber said it didn't work, and I said it did, and there was no appeal from that. So what I'm suggesting to you is that paragraph 54 has nothing to do with immunity. It's just an observation about, in rather general terms, about the boundaries, difficult to define boundaries between conduct which is and conduct which isn't.
Yes.
Harassment, or capable of being.
I take that on board, and perhaps I should withdraw my reliance in that it's further supported with the proposition of Munster and Lamb. I do rely on Munster and Lamb's proposition for this separation, that the immunity does not effectively prevent or constrain the court's ability to control its own process. Separately, there is a question whether communications of these kinds are such that would fall outside of protection of immunity of the kind that Lord Justice Ricks refers to. So those are my submissions on immunity. If I can come on then to freedom of expression. I hope I can be briefer here, not least because, again, the advocate and I are ad idem, and so I will refer the court to our respective skeleton arguments on this point. In particular, we submitted referred to in shorthand as the Article 10 skeleton argument. That is tab 1, page 1 of the supplemental bundle, which addresses these submissions, and I will simply restate my reliance on what is said there. In sum, the types of communications that are at issue are not such of a quality, they're not of a quality as to attract any protection under Article 10. There is, however, and in addition, an additional point, and I think it's important that we don't lose sight of this, and is that the rules of litigation put constraints on the behavior of those who participate in it. And so the civil procedure rules put in place stringent rules about the form in which pleadings and other filings should take, arguably constraining freedom of expression, or rather channeling freedom of expression into particular formats. More apt, perhaps, we have a mix of written rules and very strong conventions which circumscribe the behavior of participants in litigation towards one another. And so there is in my submission very little doubt, but that if I had resorted to this kind of language in court, that a judge would have been perfectly within their right to at least upbraid me. And equally, if those who instruct me had similarly expressed themselves, that would have been wholly unacceptable. And in both these circumstances, disciplinary proceedings would likely have been warranted. And in my submission, no appeal to freedom of expression or litigant immunity would rightly have availed us. Now, it's obviously true that Ms. Okunola, as a litigant in person, is not regulated. But the point whether expression of this quality attracts protection under Article 10, specifically in the context of litigation, remains in my submission the same. And so also for that reason, it is supportive of the proposition that, in my submission, there are no legally protected rights or interests that were threatened by the relief sought.
I mean, I thought you accepted this morning that Article 10 was engaged in communications by the respondent, not for everything she ever said, but engaged, so that it was necessary to at least look at Article 10.2, which says the exercise of these freedoms are subject to may be subject to conditions as prescribed by law and are necessary in a democratic society in the interests of, etc., prevention of crime, protection of health or morals, or the protection of the reputation of others, preventing the disclosure of information received in confidence, or for maintaining the authority and impartiality of the judiciary.
Well, Lord, in that case, I was too hasty and I apologise.
Okay, you don't.
My primary submission is as we set out in our Article 10 skeleton. So if I can...
Well, your primary submission is that this is out with Article 10 because it's vile abuse.
Yes. So that's
But I still don't understand. I mean, if I can just put to you, I think I already put it to you in the context of the first order, but looking at the new order, surely any message or communication which is grossly offensive about the solicitor includes the email we looked at first thing this morning, which contains 2 grossly abusive paragraphs and 2 perfectly sensible paragraphs.
Well, two answers to that, my lord. In the first instance, I do not think that that paragraph would amount to indecent or grossly abusive language for the purpose of the Communications Act. And so that's the first point.
Right.
And so...
But let's assume it did. I mean, there must have been some communications where she said something perfectly sensible in paragraph 1 and perfectly obscene in paragraph 2. I mean, not must have been, there were. And I've seen them.
Right. I'm slightly at a loss. I don't think that we have relied on communications of that kind, mixed communications.
Okay. Well,
there may have been chains in the same correspondence where one email, that may be what your lordship's referring to.
Yes. Well, I mean, there's, you know, it's very hard to disentangle it. I mean, when somebody is obviously so agitated as she was. But anyway, I mean, just assume there is such a communication. How does this apply to it? It obviously stops it.
Well, it would stop, yes, it would stop but the saving is important as well, I think, in the sense that paragraph 2 do say that we do not apply to any formal filing or any document in any legal proceedings, or the use of any such proceedings or any document formally filed in those or any other legal proceedings. So we are not seeking to constrain the making of valid points, or indeed reliance on. I struggle a little bit to. I don't necessarily want to take the court back to the messages themselves, which we rely upon, but I struggle a little bit to see how language of that kind could be relevant. But in any event, we do we do carve out.
I mean, we're not saying it's relevant. I'm never just saying it's relevant. People do express themselves in very extreme ways. And they might say, and I think she really did say, this is rubbish, your point, X, whatever the point is, which she's perfectly entitled to say in whatever language. And it's not surprising you said it because you are a ... And the you are a ... is obviously vile abuse, but it is intimately connected with her contention that what you're saying about her is rubbish. And what I don't understand is how you can properly restrain a person from making her points in the way she wants to make them when there is this immunity.
Well, the way it would work in practice, my lord, is that you would, obviously we are dealing with perspective, and so Miss Okunola would have been told that for the future, communications of this kind are not acceptable, and they have been prescribed by this order. Now, if then we have the circumstance where good points, or perfectly valid points, are followed by indecent and grossly offensive language, that would, in practice, be dealt with, I suspect, in the first instance, by sternly worded correspondence, effectively shot across the bow, that this is particularly the type of behaviour which the court has prescribed and which you must refrain from. And if you persist, then we reserve our rights to bring the appropriate proceedings. Of course, there is quite a high threshold. It's quite a high threshold then for the court, first of all, to find a contempt of the order of the court, because it needs to be satisfy all the sort of violation. But then also it needs to be sufficiently serious for the court to be able to take action, or to impose a consequence or a penalty for a contempt if found. I'm sure the court will be familiar with cases on technical contempt where it's technically found to have been a violation of a court order, for instance, but there's no reason to impose a penalty. These are situations with which the courts are confronted with, I dare say, on only a daily basis, and I don't see what the difference would be in these circumstances.
Okay.
suppose it's my learned junior makes the point that these difficulties of drawing the line are obviously the same for any court considering, in this case, a prosecution potentially for a malicious communication. If that were to be brought on the basis of mixed communications, then you would have a similar sort of threshold issues that need to be determined, and that wouldn't detract from, you know, the principle that such communications are not only inappropriate but criminal. It's an application difficulty, and I accept that there are circumstances where the application of a particular court order will be difficult. I mean, but that, as it were, that is no different from most kinds of relief which the courts apply or grant on a daily basis.
Well, you know, you've not been able to point to any case where an injunction has been granted to restrain communication, speech, in the context of legal proceedings like this, except line mile. And line mile's a rather different case.
Line mile, to the extent that it's useful to take your lordships to it, but it's obviously involved in my submission a rather more stringent prohibition of not getting within 10 meters of
yeah, but it was
lawyers,
a threat.
etc.
It was a threat which had to be taken seriously.
Well, it arose out of. My lord, I obviously take the point that it didn't specifically target communications.
And I mean, none of these arguments were raised, and it's a first instance decision, and we have to consider whether any of these arguments, which now are raised, go anywhere.
Yes, quite.
But I mean, what I'm really saying is there's not a whole pile of cases where judges are asked to make these orders routinely and do so, and then enforce them, and it all works perfectly happily without anybody getting cross. Not at all.
No, but my lord, the extent to which it was argued against me, and I think that there may be factual circumstances where the application of the order may be tricky, may be difficult. There will be cases on the borderline as to what is meant to be caught by the language of the order or not. That, as a general proposition, goes for most relief that the courts.
Well, except that Lady Justice Appellant said that you have to, and she's right, I think, that you have to only make orders that are clearly enforceable and have clarity.
My lord, an anti-harassment order, for instance, I would say would be akin to this kind of order.
Which sort?
An anti-harassment order. There will obviously be borderline cases, and harassment has a whole host of exceptions, criteria that need to be satisfied in order for it to be fulfilled. And an anti-harassment order is routinely put in place, and then of course it will be a matter for judgment and determination in respect of when there is an assessment as to whether it has been breached or not. In my submission, it would be the same in this instance.
Okay.
So moving on then to the final portion of my submissions, which relate to whether standing today here, this court should grant the relief sought as amended. And if we come back to the test that we've just gone through, in my submission, what has changed between the making of the original application some 18 months ago and today is stage one. Is there now a material risk of the interference identified recurring? And in this regard, the advocate at paragraph 22 of his skeleton, again tab 7 of the supplemental bundle, page 210 of the PDF, page 207 of the bundle, right at the bottom of the page, and over the page, a lot of him concludes that it would fall outside that purpose, so the purpose of preventing interference with the proper course of proceedings, to extend the injunction indefinitely beyond the end of those proceedings. From that point, the purpose of the injunction would in substance be to protect the solicitor's rights. And this leads the advocate to conclude at his paragraph 60 down at page 224 of the PDF, 221 of the skeleton, that the present relief is not justified as there are no substantive proceedings ongoing.
And he says, quite importantly, I think somewhere else, that there's been no recurrence since the end of the trial.
Yes.
And that's true.
That is true.
Yeah.
Now, there are 2 points, as it were, against that I rely on. And the first is that as a matter of principle, it is clear from the authorities that the inherent judicial jurisdiction is wide enough to make provision for future proceedings. Now, in PMC, this was one of the issues that this very court addressed. If we can go back to tab 54 of the authorities bundle, page 1267 of the PDF, 1264 of the bundle, at paragraph 46, your Lordship's quoted from Lord Reed in the case of A and the BBC, where you see in the middle of that paragraph, the interests of justice are not confined to the court reaching a just decision on the issue in dispute between the parties. And then it goes on to conclude at the end of that paragraph, the court can therefore take steps in current proceedings in order to ensure that the interest of justice will not be defeated in the future. And then again, further on, paragraph 109 in the same judgment, so that's page 1284 of the PDF, 1281 of the bundle. Part of the rationale for the order that was granted by this court was to protect the integrity of the court's process in various future permutations of the litigation, including the need for the court to approve any settlement reached, should such a settlement be reached, by exercising its then, what would then be, its protective jurisdiction. And so, in my submission, in the circumstance of this case, I of course accept that the need for relief is less acute as I stand here today than it was when Mr. Field originally made the application. However, given the nature of the relief sought and the limitations on the scope of the relief sought, in my submission, the court should focus on the material risk if future proceedings are engaged, not, as it were, first assess the chance of such proceedings eventuating. And this is because the prohibitions in this order, as we have seen, would only operate if and when further proceedings arising from the present proceedings are brought. As I submitted previously, it is not the case that this order would extend protection to the appellant's legal representatives as individuals. As I said, absent this appeal, when this appeal is concluded, if Ms. Okunola sends malicious communication or sends indecent or grossly offensive communications to the solicitors, this order would not bite. This is, in effect, an order that would accompany the trial order that Mrs. Justice Hill made following the trial, only coming alive, as it were, if and to the extent that proceedings arising out of that order commence.
There's a statement in one of the old cases, and I can't remember where it is, that you don't get an injunction just by saying timeo. You've got to show that there's actually a risk that the thing that you fear will happen. The submission you've just made bypasses that and says it's not necessary. Do you have a submission as to what the state of play is as to the risk of repetition on the material before us now?
Well, the state of play, Ms. Okunola is not here, and she might have made submissions on those points, but if we look at paragraph 13 of her 20 November 2025 submission, so that's in supplemental bundle tab 4. Page 106 of the bundles, that would be 109 of the PDF. Ms. Okunola says there is in short that she considers that she has damages claims against those who instruct me for various conduct which they have engaged in during the course of the proceedings, which led to the judgment of Mrs. Justice Hill.
Sorry, I don't know where you're reading.
Paragraph
This is
30.
supplemental.
Yes.
109, did you say?
Yes.
Paragraph
13. So she wants, and I quote, punitive compensation for her loss of liberty, costs for originating the claim, and victimization during her employment, and that those who instruct me should compensate her for harassment and distress. Then she submitted further submissions on the 28th of December, and you'll find those at tab 6 of the same bundle. And the relevant paragraph is 15, page 197 of the PDF, 194 of the bundle. And it's not entirely clear, but she certainly seems to suggest that this court should take this opportunity to effectively overrule a whole host of rulings that were made during the course of the proceedings below.
Sorry, could you just give me the paragraph 15?
Paragraph 15, yes.
Yeah, thank you.
So, I suppose the short answer to your Lordship's question is that there are clearly suggestions that Miss Okunola does not consider this to be over, to put it colloquially. Now, it is of course right to say that Ms. Okunola is under an extended civil restraint order. So that she herself can't bring proceedings without leave of the High Court. That, I believe, has approximately 18 months left to run. But more than that, it's obviously possible that there will be further proceedings to enforce the trial order if there are further examples of abuse or dissemination of confidential information. It is in the evidence that Ms. Okunola has effectively not been entirely, or it is certainly our case, that Ms. Okunola has not been truthful in disclosing all her and delivering up, in accordance with court order, all her electronic devices. So there is a very live concern that Ms. Okunola still detains confidential information of the nature that was the subject of the proceedings below, and that she could at any moment recommence distribution of them. And that would obviously need to result in enforcement proceedings under the order. So even if Ms. Okunola will for another 18 months be herself prevented from coming back against the appellants, the appellants may themselves need to conduct enforcement proceedings. So I take your Lordship's point, and of course, as I said, I accept that the need for the relief is less acute today than it was, but we are not simply screaming timeo.
Thank you.
My lords, my lady, I have been through the 4 broad areas that I set at the outset that I wanted to go through. Unless there's anything further that I can assist the court with at this moment.
Sorry, no, nothing.
Thank you very much, Mr. Lewis. Yes, Mr. Donman.
My lords, my lady, I'm going to address you on power first, then restraints, then the exercise of power, and then finally on the specific relief. Noting, of course, my lord, the Master of the Rolls, that you're principally interested in the 4 impediments that you identified this morning.
Do you endorse the 4 tests promulgated by Mr. Lewis?
Not entirely. I mean, it may be, as a matter of substance, there's not much difference between us, but no, I will come to that if I may. And that's one of the reasons I want to go to power, because one of the aspects of the cases is that the dignity of the court is also an important thing that requires protection, and I'll come to the significance of that in due course. And I take powers before restraints because, of course, as we learn from Abbasi, which power you're using is relevant to whether there is a restraint. So if you're using the power of Plans Patriae, the fact that the clinicians may have their own independent right to the same relief does not operate to preclude the application of the Plans Patriae relief. But if the court wasn't addressing it on the Plans Patriae basis and was only looking to vindicate the rights of the clinicians, then the fact that they hadn't taken their own cause of action would preclude the granting of the relief at that juncture. So that's why I say that power is probably best worth taking first. I do, if I may, however, have and I hope helpful, initial observation to make about what it is we're talking about here by injunctions. In the broadest sense, I would take an injunction as a court order prohibiting a person from doing something or alternatively requiring a person to do something. And that is the definition that the CPR glossary referred to in CPR 2.2.1 makes. So it is a very wide definition in that term. Now, not everything that falls into that wide definition would, I submit, conventionally be described as an injunction. So, for example, we have seen in Wolverhampton discussion of draft embargoes and draft judgments. Such orders are not equitable injunctions, but they clearly exist as a court order prohibiting someone from doing something. And likewise, one might say reporting restrictions. Now, historically, the injunction was a form of relief known as a writ of injunction. And until 1854, only courts of equity could grant a writ of injunction. And then the Common Law Procedure Act, 1854, Section 79, authorised a court of law to grant an injunction. It's a common law court in all cases of breach of contract or other injury where a party had an action. And so, at some level, that's the origin of a sort of cause of action idea behind it. And obviously, then one had the unification of the jurisdictions. But what we have in those sort of injunctions historically is injunctive orders relating to matters outside the proceedings themselves. So a party is saying, I don't want the counterparty to the contract to be engaging with person B because he's said that he'll only work for me, or that sort of thing. What we're dealing with in this case is rather different, I'd say, on my analysis, or it's at least on one analysis is different, because it's an injunction that's related to the process itself, the legal process itself. It's an internal injunction, maybe somewhat similar to the way that an embargo on the draft judgment is internal to the legal process. And such internal injunctions might not be made not necessarily because one party is asked for them, nor even has a right to them, but because the legal process itself is deemed to demand it. Now, you may ask, well, why is this helpful? Why are you saying these things? And I'd say because when it comes to the source of the power, and what I think this morning was sort of referred to as the IJJ, if I may refer to it in that sense too, or the Connolly jurisdiction, to act effectively within the court's jurisdiction and prevent abuses of its process. The order to stop abuse, significant abuse by a party against the solicitor of another, would be an injunction within that Connolly jurisdiction rather than in the conventional sense discussed. And at the risk of cutting things to the chase, and by way of sort of opening, if one turns to the supplemental bundle and at page 477 or 480 in the PDF,
You need to read that.
no. So, if a party today or before a court in live court proceedings stood up and said those words against the solicitors of another party, I hope, I'd be right in assuming that the court would consider it had power to tell that party to stop. Second position, we're midway through the trial, and overnight, communication to the same effect was sent, and that's brought to the judge's attention. Again, I would consider it unproblematic that the judge would consider that she or he had the power to say, you must not communicate to the solicitors, to the other solicitors in that way. Just in the same way as a judge will tell a witness, you are not to discuss your evidence overnight. And so one comes to the third scenario, which is of course why I make this point, but you're 3 weeks away from trial and that correspondence is being sent. What is the difference as a matter of principle in terms of the judge's power to say, you must not communicate in that manner to the solicitor at the other side? And
Well, I mean, the difference, I mean, of course, you know, you make a fair forensic point, but the difference is that the way one controls judicial proceedings is actually different to the freedom of expression in writing and within a litigation environment. And whilst you're absolutely right, the judge would simply say, stop, to the defendant, please stop. And if she didn't, then the usher would be asked to remove her from the court. Fine, it would all be over. It doesn't really tell us whether a very far-reaching injunction of the kind sought here, or rather, not whether, but when such a far-reaching injunction of the kind sought here should be granted.
My lord, I mean, I think there were at least two...
Nobody is doubting, just to be clear, the communications that she uttered or wrote were disgraceful and abusive and unpleasant, and a lot of other adjectives could be applied to them.
No, of course, my lord.
Certainly obscene.
My point was merely really by doing this is to demonstrate in my submission, the commonality or the almost identity of the situation being presented to the court as a way in to demonstrating how that Connolly jurisdiction finds its articulation or its enactment through judicial order restraining conduct. Now, to my lord's point, well, the freedom of expression would operate in a different way. I mean, I have to say, respectfully, I don't immediately understand why, in the sense that in either case, the court is having to take a view either that what is being said doesn't engage Article 10 at all, or if it is, saying, well, what is being said engages Article 10, but is to be restrained by reason of respect for judicial authority under Article 10.2. So on the human rights aspect, I don't think I would accept the difference. Now, on my lord's other point, well, the form of court order is different. Yes, that may be so, but whether it's a decisive difference is a separate matter in terms of the availability of the power. Now, obviously, my lord, you made the point, well, this is an extremely broad injunction being sought and so on and so forth, and respectfully, that is raising a very important point, but that goes to the nature of the injunction actually being sought by the appellants in this case, rather than the point of principle. Although, my lord, I do hear your fourth sort of impediment, which is, if I have understood it right effectively, is this workable? Because people find litigation stressful and express themselves unwisely frequently, and is the jurisdiction of this nature a feasible one? And that's a fair concern. But I think why I started with this at the outset is to show that if at the extreme of a communication like that, one accepts that a judge is allowed to tell someone not to do it for the pendency of the proceedings.
Well, of course, as Baron Alderson, or whatever he was called in very haughty terms, exclaimed, that he was the judge, he could do what he liked.
Exactly.
But we don't really operate quite like we did in those days now. We are rather more indulgent to litigants, and we would even treat somebody who was reading out that amazing text with probably greater, what should we say, consideration.
Yeah.
We would probably think that there might be some mental health problem involved, or that the person needed care and assistance, and we would get them ushered out in a nice way and calm down. I mean, it's really a long way from granting an injunction that you have to express yourself in terms that make it quite difficult to know whether you're actually contravening it. I mean, some people do use bad language, which could be considered offensive or obscene, quite naturally. It sort of flows out of their mouths. They don't even know they're doing it.
My lord, of course.
And injunctions to stop people talking in their normal language, or to include something which you and I, as lawyers of years of experience, can say is utterly irrelevant. These individuals are not lawyers, they're not trained, and litigation is a stressful exercise, so it's even more likely that they will express themselves in that way. My concern is to, as you rightly identify, is not to lay down a series of tests which are unworkable or always have the same answer, but to do, if we're going to lay down anything, it must be entirely workable and applicable to situations that frequently arise if people are going to ask for these injunctions.
My lord, that's right. I mean, one of the difficulties of the court is that at some level one's talking today both in the generality and in the specific instance.
I mean, it's, you know, speaking quite bluntly, it's perfectly obvious that somebody is very, very concerned about this because they brought this case, notwithstanding that she hasn't said anything horrid for 18 months. So I'm distracted. It's a lot of money to spend to have an argument about somebody who actually was, you know, charming this morning.
My lord, indeed. And so those are by way of initial points. Now turning to the power and trying to take this relatively swiftly, given that much has already been covered. Obviously, we understand that jurisdiction has this duality, both in terms of the strict power, but also the strict power having to be exercised in terms of principle. We have a long history of cases which deprecate the abuse of parties, witnesses and others. I don't want to labour the courts, but if I may, I hope not taking up too much time, we can start at tab 10 of the authorities bundle, Kit, Kat and Sharp, at page 61, which is 64 in my lord's PDF. This is obviously a venerable case, 1882, and even more venerable in the sense it goes back to the 1742 case of Roach and Garvin, in the first column being cited there Lord Hardwicke, saying that 3 different sorts of contempt. One is scandalising the court itself, contempt of court in abusing parties who are concerned in causes here. There also may be a contempt of this court in prejudicing mankind against persons before the case is heard. And that case, in which the defendant was threatening to send letters publishing a statement of the case with pejorative remarks, he was saying it was top of the second column, both abusing a party concerned and prejudicing mankind before the cause is heard. And the only reason I really go to that is that it's a theme that runs through subsequent judgments too, that the concern of the court in terms of protecting the integrity of the court process is not solely to prevent actual interference with the justice being administered, but it is also being concerned with effectively the integrity and the dignity of the process itself. Moving on to read Johnson at 14 and page 116 in my Lord's 119. Picking up Lord Justice Bowen, the law has armed the High Court of Justice with the power and imposed on it the duty, just pausing there. That's obviously very redolent to the language in Wolverhampton. I think it's paragraph 18, which makes that same point. Power and duty to prevent bravi manuum by summary proceedings, any attempt to interfere with the administration of justice. It is on the same. It is on that ground that insults to judges are not allowed. It is on the same ground that insults to witnesses to a jurymen are not allowed. The principle is that those who have duties to discharge in a court of justice are protected by the law, shielded on their way to the discharge of such duties while discharging them, and on their return therefrom. And one of the issues in that case was that the solicitor in question had been threatening to another solicitor after court rather than in it or before it, and it doesn't make any difference. The case of Banji, we were taken to this morning. It's tab 28 and page 538. At paragraph 13, just trying to pick up additional points, but paragraph 13, one of the points that Lord Justice Brooke had taken as cited is that the category of case in which the court should be willing to exercise this power is almost by definition never to be closed. If my lord, the court was to conclude that the power existed to grant an injunction to prevent, pending during the proceedings, of abusive communication to solicitors. Respectfully, that would not be an extension of the law in principle. It would just be a further instance of its application. Now, paragraph 14, we have the reference halfway down to, in recent years, there have been a number of occasions set out in the judgment of Brooke L.J. in Ebert, paragraphs 30 to 32, in which the court had recourse to its inherent jurisdiction when controlling the activities of litigants litigants who have abused or attacked court staff, generally wasted time of court staff or misbehaved in court. And my own friend, Mr. Loof, took you to that case this morning. Just, if I may, to pick it up again. I'm sorry to have to trouble you in doing so.
Is this not a different case? If I remember, the Eberts were very active litigants in many cases.
Yes.
This is the Attorney General against Ebert.
Yes, this is the same case as just referred to, and I will admit to that's how I identified the case as I was preparing, and I saw this case. So it's 2 All ER 789.
Okay, which page do you want?
And opening the case, we can probably pick it up at paragraph 24, which is page 796. Mm-hmm. So this was the relief that the Attorney General sought. Barred from entering the RCJ, and importantly, secondly, he should be barred from any form of communication with anyone at the court, except for the purpose of making the formal applications mentioned in the draft order. So it was a restraint on communication. And in making good the application, Mr. Garnham for the Attorney General, and I pick it up at paragraph 30, which is to what the Court of Appeal was referring in Banji. So 3 judgments. The first, a litigant who spat at a clerk, and the injunction there was 1 about what action he was proceeding, and 2 entering the civil court premises. Paragraph 31 was perhaps more pertinent because that involved an order that the litigant should not communicate with the Crown Office, save only in writing. And in paragraph 32, a protection of the staff of the Court of Appeal. Paragraph 33, I think we've already seen, and this is the point that, you know, contempt proceedings and an injunction serve different purposes in the sense that the injunction is being sought prospectively to prevent inappropriate conduct. At 35, I should say this was Lord Justice Brooks' judgment in the divisional court. At 35, he accepted that the court's supervisory role includes regulation of the manner in which the court process may be utilised. And at 39, we see the same point being made by Mr. Garden. Could have taken committal, but asking to restrain future conduct. Mr. Garden's submission was that for that purpose he had to show a substantial likelihood that such misconduct would come in due course, would come to the exercise too. But I don't disagree that there needs to be a significant prospect of such misconduct in the future. And then at 41, the Attorney General is entitled to the relief he seeks. So there, the Divisional Court granted relief not to communicate with the court staff. And one might ask rhetorically, if injunctive relief is possible to protect court staff, why could injunctive relief not be possible to protect solicitors in the appropriate case? And I appreciate, my Lord, that possibly everything lies in that last qualification. Then to runting, so going back to the authorities bundle, tab 21, and picking it up at page 334, which is my Lord, your page 337. Now, this was a case where a photographer had pursued a defendant outside court, and on the facts, ultimately, it was considered that there wasn't any contempt. But the point of principle at the top of 334 is notable. The law insists that a defendant, witnesses, and indeed anyone else who has a duty to perform at court is entitled to go to and from the court, that is, between his home and the court, whether on foot or otherwise, without being molested or assaulted or threatened with molestation. And then I just go on to the next paragraph. Perhaps I could invite you to read the next paragraph.
Sorry, I've lost my place.
I do apologise.
You're in Runting, yes?
Yes, exactly. It's page 334.
Thank you.
Which paragraph do you want us to read?
And I'm so sorry, it's not numbered, but the second. There were two reasons for that.
Yeah.
So the Reed Johnson we've already looked at, of course. But the reason I took you to that paragraph is because of the two reasons that are given. And one of them is, in effect, the actual interference point, nothing to create in the minds of persons any fear to make them want to come to court and so on. But the second also it exists, that the authority and dignity of the court require that those who attend the court to carry out their duties should be allowed to do so without let or hindrance. So one of the propositions that my learned friend put forward in terms of his tests was that there must be a significant interference with justice. I think reframed this afternoon, the conduct must be unlawful. Now, on the significant interference with justice, arguably that captures part of it, but not the whole, because in the same way as the example of within court, someone is grossly offensive. Now, it may be that nothing actually happens as a result in terms of the effective administration of justice, but the court's dignity is damaged by that sort of thing.
I do think we have to bring this into the 21st century.
I agree.
I think judges are rather less concerned about their own dignity than they may have been in the 19th century. And indeed, the word itself is pretty outdated. And I just think that we need to be very careful to ensure that we are considering this issue in the context of modern life and modern conduct of litigation. It isn't, the world is not as it was. The advent of technology, instantaneous communication, the internet, artificial intelligence, all those things have changed the way we do everything dramatically. And the court and the common law actually changes to respond to cultural and innovative changes. And therefore, although all these cases I get, there is a line in Runting which is quite helpful because it talks about it being very difficult to draw a dividing line between trivial acts which couldn't amount to unnecessary interference and serious acts which might. And says that's jolly difficult. Well, I expect that's jolly difficult in 2025 as well.
My Lord, exactly.
Or even 2026.
I respectfully entirely agree with my Lord's proposition that any consideration of the appropriateness or otherwise of conduct must be contextual, must be modern contextual, and probably tomorrow, but we may have a look at the observations in Cassily, where there's discussion of whether an email is grossly offensive for the purposes of the Malicious Communications Act. And effectively, precisely that sort of contextual response is granted, but adopted. But I suppose my response to my Lordship's point is that seen properly and contextually and realistically, there still may be circumstances where there is conduct within court or outside, which a court in modern day would say that it's just totally unacceptable. And it's totally unacceptable, and I'm not necessarily saying that the facts of this case amount to this, but in the abstract, the possibility that something could be totally unacceptable, and for the court to say, we're not going to condone this, that doesn't of itself necessarily, on this sort of authority, require that there has actually been some interference with the course of justice, although presumably in many instances it may. That the idea of a contempt of court isn't necessarily coextensive with actual interference, is I suppose the mere point I'm trying to make. But my Lord's point as to whether on the facts of any particular case that would be a distinction that actually would arise is perhaps a fair one, at least conceptually.
It's a word, the word authority, which is in that second formulation, is to be found in Article 10.2 as well. I've always taken this to be not about the dignity of individual judges, or really about dignity in the archaic, well, in the sense that we use it today, but more about the standing and reputation of the court as an institution
Exactly, my
administering
lord.
justice. So
Exactly, my lord. And it's the public hearings heard by the public, witnessed by the public, and so on. So it's the authority. Yes, I mean, my lord, you make the point better than I did myself. So I adopt your formulation. The next authority is the Attorney General Yaxley Lennon, which we find at tab 40, and this was a case involving live streaming video outside the Crown Court while the jury was in retirement. But among the facts, and we pick it up at page 783, which is also 786. And by H in the report, we see the third contempt alleged by the Attorney General was that by confronting some of the defendants as they arrived at court, doing so aggressively and openly filming the process, the respondent interfered with the administration of justice. At 25, so page 788, we have at the present Dame Victoria Sharp stating that contempt of courts is principally a common law doctrine to protect the integrity of civil and criminal proceedings. And to that extent, plainly, contempt of court and the IJJ, or the Connolly jurisdiction, sort of spring from the same well, as it were. The points that follow include reference to runting that we've seen at 26, and then moving through to page 803 in paragraph 78. And perhaps I could just invite you to read 78.
Yeah.
So again, it's making the point that there's both the risk aspect, but also the authority aspect. And then that follows through in the judgment of the Divisional Court at 80 and 81. So at 80, just above E, it is fundamentally a matter of respect for the institutions and the process by which justice is administered. And then at 81, just saying that there's no proper basis to limit the application of this principle to acts of physical rather than verbal molestation. And then finally, by way of
191, I would have thought.
I do apologise, my lord. Bear with me. I will return. So sorry.
Yeah.
I'm sorry, my lord. It's just taken me Paragraph 91, was it, my lord?
Yes, it says Article 10 is no excuse.
Yes, exactly. Exactly.
I don't know whether that was argued.
Now, obviously, we'll come to Article 10 in due course, but if you know, I suppose the obvious point is once you've got to the stage of something being, in effect, equivalent to a contempt of court in that way, then even if it gets to engage Article 10, the justification almost follows from that characterisation. Now, one of the points that we'll see tomorrow when looking at Casserly is that grossly offensive is considered, must bring within it the Article 10 consideration. So I'm certainly not saying that Article 10 doesn't fall to be considered when considering the conduct, but once you've established it's a sort of a contempt, it's hard to see how any restriction could be out with Article 10 too. And then the last case is the line mile case. Now, I appreciate that caution obviously must be taken with this in the sense that it certainly didn't have the fullness of discussion that it has been before this court, and it had as close consideration, doubtless, as the court will in due course give to the matter before it. But nonetheless, it was an appeal from a county court decision, and at page 1044, so at 1047, we have the court, the High Court judges, no, sorry, the County Court judges' observation that the claimants had the entitlement to go across the land without harassment, threat, or assault. And then at 18, two other freestanding purposes. And the freestanding perhaps has some significance given at Bassi subsequently. So prevention of unconscionable conduct and the protection of the court's own processes. So you know, an injunction can be justified on a number of potential grounds. In the judgment, we have it at 17:1046, the reflection from Fourie and Leroux that jurisdiction had both power and principal aspects, and then over the page at 21, the legal framework, broad idea that Siskina, in effect, no longer good law was accepted at paragraph 32. So to that degree, Mr. Justice Sweeting can't be faulted. And then the further point at 36, effectively that there's no limit to the practice of the court for necessary and reasonable applications ancillary to the performance of its functions. Now, in effect, the question of limit is the one that this court asks me to address you on today, but broad idea wasn't a limit, and so to that extent, again, Mr. Justice Sweeting hadn't identified any insuperable obstacles, and then at 38, he didn't make an order which amounted to a freestanding remedy divorced from the litigation. There's sort of pausing there. The remedy here was, in the sense I opened with this afternoon, internal to the litigation. It was for the purpose that when it finally was decided, you know, for that period of time, there wouldn't be further threats or abuse. And at 42, the conclusion in a sense, Mr. Justice Tweeting put it the other way. He said, well, I have the power, and there's no settled principle that it shouldn't be used in the circumstance of this case, so by reference to the, sort of the breadth of the power. And he considered it was entirely conventional, based upon, as it was upon factual findings, as to conduct that was inimical to the proper conduct of litigation. And I suppose the only point I don't rely on this case as evidence of any binding sort of principle for yourselves, obviously, but it does perhaps indicate that at least, well, two judges, the first instance and Mr. Justice Sweeting, considered this to be relatively unproblematic given the conduct with which they were dealing. Now, to my Lord the Master of the Rolls' point, it's right that the conduct was different. And so we'll have to address that when we come to the specifics of the case. But that the injunction involved a restriction upon communication to solicitors of a party, those solicitors not themselves being party to any cause of action, it is to that extent similar. So, my Lord, that's what I wish to say about the power. And with that done, would then turn to the restrictions. Now, I won't go to what Wolverhampton dubbed the supposed limiting principle of the Siskino's restriction. I understand you don't need to be addressing the first restriction I'll address is whether the availability of a private law cause of action for the solicitors in this case precludes the granting of the injunction sought.
I don't think anybody said it precluded it. I think it said it was suggested it might be relevant to it.
Well, my Lord, I certainly didn't mean preclude in a manner of strict power. As to the question of whether it precludes as a question of principle, there's a sort of dual answer to that in my submission. Yes, it would preclude it insofar as the injunction was sought to extend beyond the proceedings which the Connolly jurisdiction was seeking to protect. I'll obviously come in due course to my learned friend's submission that there will be future proceedings, and so you can sort of prospectively anticipate those. But in broadest terms, if you had the proceedings ending in November, subject to any appeal, the Connolly jurisdiction or the IJJ wouldn't justify a permanent injunction against the party from contacting the solicitors, because it wouldn't serve the purpose of protecting those proceedings after them. But while the proceedings are outstanding, respectfully, the analysis of the Supreme Court in Abbasi does, in my submission, indicate that it's not relevant to whether the injunction should be granted. Because in Abbasi, effectively, the court says, well, this order, while proceedings for the child's treatment are ongoing, is justified on the parens patriae. It may also be justified for the purposes of the protection of justice in proceedings. And that being the case, it's frankly irrelevant if clinicians could have also got the same. We're not going to deny the remedy available under the parens patriae jurisdiction because the clinicians could have got the self-same remedy themselves. I mean, one could go, it's obviously a very long judgment, and one could go to a number of places in it, but going to page 1240, which is 1243 at paragraph 182, which are the overall conclusions. And point 1.
1240.
1240, I think yours 1243, my lord. I'm sorry, but I haven't quite worked out whether everyone is using your pagination. I should have asked.
I've got my own.
Okay. Well, if it's so paragraph 182, subparagraph 1, we have the jurisdiction arising under the inherent parens patriae powers and under its inherent jurisdiction to protect the administration of justice. And then one might note at subparagraph 4, grounds of jurisdiction are not mutually exclusive. And so what one has after, obviously, I mean, there's a lot of detailed points one can make about this case, and one of the points is that the Supreme Court anticipates a cooling off period, which after the end of proceedings, to give, amongst other things, an opportunity for the clinicians to take such steps for their continued protection as may be necessary. The fact of the cooling off period existing rather demonstrates that the parens patriae jurisdiction that's being talked about is the jurisdiction in the principal sense rather than the strict power sense. But, then we have at 13 on 1242 or 1245, subparagraph 13, after the cooling off period, to protect the rights of the clinicians, the application should then be made by those individuals relying on the relevant clauses of action. And so Abbasi is authority for the proposition that the availability of a cause of action for a person that might benefit from the injunction immediately being sought is not of itself a limiting principle if that injunction is justified on a different justifying principle. And so that was the reason why, respectfully, the application doesn't need to determine whether the solicitors have the ability to take a harassment claim or a malicious communication claim, because if the jurisdiction is justified under the Connolly jurisdiction, that's not necessary because it's justified under the Connolly jurisdiction. And if it's not justified under the Connolly jurisdiction, then the injunction shouldn't be granted because or alternatively the equitable jurisdiction. If the
Yeah.
only way it could be granted is by reference to the
I mean,
initial-
I'm really not sure Abbasi is particularly significant in this at this juncture, because Abbasi simply said that you should look to domestic remedies first before you start going into other things. And here there's possibly a connection, I'm not really sure for certain, between the abuse and the process of the court, if there is such a connection, and if that can be justified, and if it interferes, according to Mr. Loof, significantly with the administration of justice, you might get an injunction on that ground. And the fact that you wouldn't get a harassment won in the name of the solicitors on a freestanding basis might be interesting, but possibly not particularly conclusive. But if there is no such connection, and the fact that, and if the injunction is really broad for the solicitors to stop them being annoyed, and not because of the interference with justice, and that connection is not made out in any meaningful sense, then of course the harassment claim is rather important. And but this court can't deal with it because it's not made. So
exactly.
Yeah.
And to that, so if the court seized of the application says, well, the jurisdiction under Connolly isn't made out.
Well, I mean, it could just be a sort of I can't think of the right word, but it could just be put forward as a bit of a Trojan horse. That actually this is not what it's about. It's about protecting the solicitors from being upset. That's what all the evidence is about, and that's what the judge really thought.
And then one might get into the fact that this is a jurisdiction where the court plainly would have a discretion, and it could be perhaps refused on that basis.
The court might just say that they fell at the first or second hurdle.
Well, if they fell at the first or second hurdle, then that is on the basis that the Connolly jurisdiction isn't made out. But I think the proposition you're putting to me is, well, what if it would amount to an infringement on the authority of the court or the interference with justice, but the ulterior motive is actually all about protecting the solicitors? In that instance, should you decline to exercise the jurisdiction? I mean, I don't think I would say that you couldn't decline the jurisdiction for that reason, but I think it's not a limiting principle in the way that would preclude the exercise, if I can put it in that sense. I mean, it seems to me that what the Supreme Court is saying is that, you know, two things can be true at the same time. The jurisdiction is justified uns parens patriae, and it also serves the interests of the clinicians. And the fact that both of those things are true is not a problem. And if someone was grossly abusive within court, and the court says, well, I'm not standing for that, or overnight, as an instance of communication was brought to attention, I don't think it's a reason for it necessarily precluding the exercise of judicial intervention by saying, oh, well, you're just trying to protect the solicitors, if at the same time the conduct complained of is completely unacceptable. Because it would put the court into a position of saying, well, we condone this, and for us to do anything about it, you've got to take action. Now, that also has practical implications, of course, because in the facts of this case, the application was made 3 weeks before trial. So the sort of interference with the course of justice starts to get rather greater if you're also saying, well, rather than prepare for the substantive trial, in order to protect the solicitors in the run-up to substantive trial, they need to actually divert themselves into satellite litigation on a harassment action. I mean, that starts to become problematic, I'd respectfully suggest.
Well, you don't condone it by not being oversensitive to it either.
Well, and the oversensitive is, of course, that's a sort of a threshold question, and that's on the facts, and we can come to that. But assuming for the purposes of this argument on jurisdiction and principle that it's not something that is about being oversensitive, it is just beyond the pale, totally unacceptable, does the court say, well, you've actually got a domestic remedy to do something about it? Now, to my Lord's point about domestic causes of action, I think there were 2 points that were explored in Abbasi. The first is whether the existing injunction would continue beyond the end of the proceedings, and that's the point to say, well, no, the clinicians have to do something about it. And then the second sort of secondary point was, well, in doing something about it, can they just rely on Section 6 of the Human Rights Act as read with Article 8? And that's the point where the court says, oh, and you also just can't rely on Section 6 and Article 8, because Section 6 finds its effect in these, or Article 8, sorry, finds its effect for these purposes through domestic remedies. So you can't just say, well, I'm just going to proceed irrespective of domestic remedies by saying that you've got to protect my human rights by reason of Section 6 of the Human Rights Act. So that reference to the domestic remedies in that sense is a subtly a distinct one in my submission. So that was my, and I was going to just take you briefly to read G on this same point. That's at tab 45 of the authorities bundle. This was the case, as you'll doubtless be familiar, where an injunction was sought against family members of a patient who lacked capacity, which included, and going to page 965 or 968, paragraph 14, which is the long paragraph on that page. And you see at B, the injunction, the details of the restrictions were set out in considerable detail, but included they must at all times treat the staff, servants, employees of the hospital and care homes with courtesy and respect, and also should at no time behave in a way towards any person working at that hospital, care home or CCG that would be considered rude, challenging or threatening. So that was the order in issue. And the injunction was granted in substantially those terms, and we see that in paragraph 21. And then family appealed, including on the basis that there was no legal or equitable right in issue, and the Court of Appeal dismissed that appeal. But in the course of, there was an alternative argument that was run at paragraph, or discussed at paragraph 80 and 81 on page 981. Because Mr. Brownhill had added an argument from the PFHA 1997.
So which paragraph?
Oh, so sorry, it's paragraph 80, my lord. maybe if I can just invite you to read 80 and 81.
Yeah.
So Baker J, Lord Justice Baker, was in effect saying, well, that wasn't the basis of the injunction. It may be that they could get a remedy in that different way, but that fact is nothing to the point. The injunction was granted on a different basis.
I think, isn't the more difficult question one that envisages a situation where the threshold of seriousness may be met, but if an action was brought for the private law cause of action, it would not succeed. You've said, well, it doesn't matter if we would get the same relief a different way. That's irrelevant. Quite easy to see that. But maybe not in Re-G, but there might be a case in which there would be an obvious cause of action for the individuals concerned, clinicians in Abbasi and here the solicitors, but where the contours of that cause of action were such that it would not be successful. And then it could be said, well, whatever the motives are, it's relevant to consider when deciding whether to grant an injunction in the exercise of this power, that the people whose behaviour is affected by the conduct would not be able to stop it using the cause of action that Parliament has created.
My Lord, I see, well, in a sense you're putting the reverse consideration.
Yeah.
Not that it precludes it, but in some circumstances it may work in favour of the granting of, precisely because there's no other.
Well, it might work both either way.
Well, I think
at the stage of assessing the proportionality, the true necessity for the order.
I mean, I think my answer to the point is that one would have to be, and bearing in mind that necessity for whatever, if jurisdiction is found to be workable, one doesn't want to have a determination both of the prospect of a, component elements of the possible criminal offence being met, and also being considered whether it would offend the dignity of the court, the authority of the court, or whatever else. So I think my response to the point you raised, my Lord, is that, well, my primary response is that the court would have to be satisfied that this was totally unacceptable from the perspective of the integrity of court proceedings. Now, if the conduct was obviously such as would be unlawful under a different statutory proceeding, then that would just go to reinforce why it's totally unacceptable. It may also be certain circumstances where the contempt of court or the conduct would be such as to be the contempt of court, but that would be the only form of criminality involved. I think it would be risky for this jurisdiction to have to ask judges to work out what the prospects would have been of an alternative remedy being sought, for example, by the solicitors. So both problematic in terms of workability, but also unnecessary, more respectful submission in terms of principle, because if the court was satisfied that it was inimical to the proper administration of justice to the requisite degree, then that's the end of the matter. Save if there are other reasons, or there may be reasons not to exercise the discretion, such as it can't find a formulation of words, or that was past conduct but it's not going to be repeated, or any number of such. But I think it would be problematic if one had to say, well, okay, well, let's have to think about whether this would alternatively constitute harassment or malicious communications or things of that nature.
Thank you very much.
So my lord and lady, that was my response to the first impediment. And note at the time, I'm obviously very happy to continue into the second, but I think I'd be unlikely to
continue. We'll rise a point.
So the next point is immunity from a suit. And effectively, my submission is that the principle does not operate such that a court cannot restrain wholly gratuitous and grossly offensive communication from a litigant to parties' solicitors. Before I come to my 3 points on this, respectfully, my Lord Justice Warby, I think obviously you were completely correct about Iqbal number 1. Immunity wasn't raised in that matter as I read the case. And in part that's why I will start with Iqbal number 2, which is at tab 34. So this is the second stage of the litigation when Mr. Iqbal had brought a further claim against his former employers, Dean Manson solicitors, this time for defamation, and the solicitors applied for summary judgment on grounds that all the publications relied on were made on occasions of absolute privilege. The narrower context of the decision, we can pick it up at paragraph 29, which is on page 662. Documents 20 and 21, which are the sole publications in issue on this appeal, both witness statements made in cost assessment proceedings. And then there is discussion as follows from of the principles of the immunity, and we have the rationale from Munster and Lamb being, effectively to protect persons acting bona fide in their statements. And at 32 at page 664, it is not enough for the defamatory language to be irrelevant to the matter to fall outside the privilege. It has to have no reference at all to the subject matter of the proceedings. And at 36 over the page, what is said by a witness outside his status or character as a witness will not be covered by privilege. And then at 42, the limits of the privilege have also been drawn in other contexts. Thus, the privilege does not apply to prosecution for perjury or to contempt of court proceedings. So the first point is just, it doesn't apply to contempt of court proceedings. Now, if you think about that, what I would totally say does that mean in reality? And it obviously means, I would submit, that if someone says something that amounts to a contempt of court, he's not immune from prosecution for contempt of court. Now, given the proximity of contempt of court and the inherent jurisdiction to control and protect the court process, that is of plain relevance in my submission, because it is immunity from suit, and A, that's not, it doesn't extend to committal proceedings for contempt of court, but B, from the language too, it's not immunity from court action. And this is the point that I would seek to derive from Munster and Lamb, and I'll go back there shortly. But the first point is that it doesn't apply to contempt of court. The second point, at the end of paragraph 42, is that statements which are wholly extraneous to the investigation, irrelevant and gratuitous libels, are excluded from the immunity. So there is a type of comment that doesn't fall within the protection. Now, there was obviously further consideration in my Lord's judgment in the subsequent case of Iqbal that came before him, which is at tab 35. And if we go to paragraph 70, at page 698 or 701, and the formulation that you reach there, my Lord. Again, a statement which is wholly extraneous to and has no reference or connection with the legal proceedings in question will fall outside privilege.
It's not legal professional or legal litigation privilege, is it?
No, it's immunity privilege here being discussed.
In defamation laws, often those terms are often used interchangeably.
Oh, right. Okay.
So what I was talking about here was the immunity that
That's as I understood it, my Lord. Yeah. And then at 72 on page 700 or 703, my Lord, you made the point that it was difficult to see a principled basis for distinguishing correspondence and other communication.
Sorry, which paragraph?
So paragraph 72. So effectively, what are the forms of writing that this immunity can extend to?
Yeah.
And point that it may go beyond witness statements to other aspects of.
May go to correspondence.
Exactly.
You say that's right?
Yes. Well, I'm certainly not in a position to disagree, and given the articulation of the principle, it's difficult to see why it wouldn't extend. And then at 77,
yeah,
the point being made that privilege attaches to the occasion, but not necessarily everything said on that occasion. I will, my Lord, have to address you on the sort of workability question in due course, of how to distinguish in mixed communications and so on. But for the purpose of the immunity from suit aspect, to that degree, one can look at a mixed communication and say, well, some things are within the immunity and some things are not. And as I say, the suggestion is that wholly extraneous slander, sorry, the formulation has momentarily escaped me in the prior case. We saw irrelevant and gratuitous libels, I think was the terminology.
So would that be a convenient moment
It would, if I, say if I could just make one point tying it together, which is to say that these three aspects, the marks don't come within the doctrine if they're gratuitous and highly extraneous, that it's not an immunity from a court action, and nor is it an immunity from contempt of court. All do sit together happily, because if a person is making substantive comments about the litigation, even in, ill-advised language, but they're substantive comments being made, then it's hard to see that that would be a contempt of court. And it's also would not be wholly extraneous and everything else. But in the event that you had communication of the example that we looked at earlier, that's wholly extraneous, I would respectfully submit, and it's also potentially would come liable to offending the court's, the integrity of the court process. And so immunity from suit doesn't preclude the application of the granting of this type of injunction being sought. My lord, at that point, yes, I have nothing else to add.
Very good. Well, thank you very much. Well, how long do you expect to be in the morning?
I will endeavour to be as brief as I can. Maybe an hour to an hour and a half, if that.
Okay, thank you very much. We'll sit at 10:30.
Court rise and table.